So welcome back to installment number 5 of Pardalis and Nohavicka's Depot training. Today is a very special day because we have one of our colleagues who's going to be conducting a deposition today, and we wish him the best of luck. So I've kind of geared today towards that, towards helping out and reminding our attorney what it is that's expected of him today. So just to go over, we're going to first direct our attention to the court reporter who's there. And we're going to ask them, after, of course, we give them a copy of the caption and the people who are going to be present to conduct the deposition and to defend the deposition, your card, whatever, all that information for the court reporter. And then when everybody's there, we're going to ask the court reporter to please swear the witness in, get the first two on, okay, which means the name and address, but we just say get the first two on. She'll know exactly what you mean. And we're going to say, give me the green light when you're ready to go. All right, nice and calm. Everything's going to get set up. And you're going to begin the deposition with, of course, your beautiful introduction of who you are and what you're going to be doing there with a couple of instructions. Excuse me. And I think today you have to really focus on this one instruction, which is that if you don't understand a question, just let me know, and I will rephrase it for you into a form that you do understand. Okay, so that's an important thing to do. You're gonna have your instructions there. You are not going to ask do you know questions, okay, because the answer to that is going to be yes or no. You're not going to let them get away with I don't know questions. When you get an I don't know, again, you should be very happy about that, and you're going to follow up with, well, who does know, and how did you hear about this? Is there anything that would refresh your memory? Any kind of logs, emails, any records at all, computer records, cell phone records, documents laying around the office, a diary, anything. And asking them if there's anything that might refresh their memory. Or something as simple as, when's the last time you heard about this? Let me just shut that off for a second. Sorry, guys. So you're not going to let them get away with the I don't know. Okay, counsel? You're going to be in control of it. You're going to be respectful, and you're going to, on the record, you're not going to use a first name basis. It's not recommended. Just refer to them as counsel. Keep it business-like with your opposing counsel there. Keep it polite, but business-like. You're not going to allow your opposing counsel to say things after you've asked a question. I don't understand the question. You're not going to let them say that, and you're going to stop them right at the beginning the first time that you hear that by saying that, I mean, you don't have to be so discourteous, but you can politely say that the question is not for you. And if you were here when I gave the instructions in the beginning, I said that if the witness did not understand the question, then they would let me know, and I would have the opportunity to rephrase it. So you just remind them about that. And then you have to add on, I'm afraid this is important, you have to add on that what you're doing, counsel, is a verbal nudge, and you know that's inappropriate. And then you might want to go even a little bit further and instruct the court reporter to, quote, mark this for the court's attention, close quote. Some attorneys have never heard that before. It's not in any of the books, but I think you'll like the effect that it has. And if you actually need it, you know, some of the court reporters actually put an index in the back, and they may, if you're doing this enough, they may have a bunch of pages that refer to how many times you said mark this for the court's attention for when you're making your motion for sanctions and stuff. You don't have to go reread the whole transcript. So that's a nice little effect. You just remind counsel that if they have an objection, just state your objection. And if they don't give you remember the Marvel Acts objections, M for multiple, A for assumes the fact not in evidence, R repetitive, V vague, I irrelevant, L leading, A argumentative, C confusing, and S calls for speculation. Okay, those are your Marvel Acts. That's why you have to memorize them and make them part of your arsenal. You know, and I just want to remind you here, and I don't want to sound didactic. I mean, even just using that word didactic makes you sound didactic, but it's not enough just to learn this, to hear this stuff, the procedures and protocols for the deposition, for the examination before trial. You have to obsess over it and really master it and get out there and do these depositions. So you should be grabbing at the opportunities for doing the depositions and constantly referring back to your notes to see how you can improve, and look for those opportunities where you can really hone your skills. Keeping in mind too that you have to tell your opposing counsel to state their legal objection. All right, not that, well, I really don't know what that means. That's not an objection. You have to state it in more relaxed terms. Objection confusing, objection vague. As I said, it has to be specific so you have the opportunity to correct your question. If you disagree with the objection, say, counsel, I disagree. Can you please direct your client to answer the question? If they refuse, you can't just say to the attorney, are you directing your client not to answer the question? That's probably not enough to set your foundation for sanctions, if that's where it's going. You have to make sure, you have to ask the witness the question, and then you ask them, are you refusing to answer the question? And then you go to counsel and say, counsel, direct your client to answer, or direct the witness, not direct your witness to answer the question. If they say no, I'm directing to not answer, and then you have your record, and that will be enough for you. You take those pages out of the transcript, and you say mark it for a ruling, and that'll be enough, and it'll be marked, and you'll have that page to go to at the end. Okay. Don't allow your opposing counsel to rephrase the question for you. They think that they're doing you a favor because they're so experienced and they're so great, and their mastery of the English language is, really, really, incredible. It's okay. You say, counsel, I appreciate your assistance, but please, I am just asking you to not speak while I'm conducting the deposition. Okay, it's improper. You know it's improper. Please don't do it anymore. Okay, so we're going to remember, to have the question and that little colloquy there marked for a ruling. Okay, and then you can go after them. My advice is to make the motion. I know that attorneys are taught to have a court on standby and make your call right there. Especially right now, the courts are extremely busy. The trial parts are busy, the motion parts are busy, and chambers is busy. Just if you can resolve it by motion, if you don't need that information that second, I would just hold off, mark it for a ruling, and go make your motion. And I know this it's giving the court extra work, but at least it's on their time, and they'll do it when they can get around to it. So just keeping in mind that the situation that we're in, remember this is October in 2020, so we have a little situation going on, and we want to be mindful of that and remember that the courts are overburdened anyway, never mind in a situation like this. Okay, so, and also we're not going to forget, counsel, that when you ask a question, if the answer is not responsive and they're running off and giving all this gratuitous information, you're going to object and move to strike. The answer is not responsive. And you could also take the opportunity to drive that wedge between the witness and their counsel by asking the attorney to advise their client to answer just the question. Sometimes they'll do it. It's a good thing, but you should not if they ask you to do it. All right, just your response should be just ask better questions or something like that. But don't let opposing counsel drive a wedge between you and your client. Okay, so that's my my reminder of what to do today for your deposition. We're going to go over a couple of things, and I'll get back if we have some time at the end to go over a couple of other reminders. So right now we're just going to continue. When we last left off, we were discussing dissecting the frog, that deposition transcript that we had as a sample. Okay, and I'd like to get to that right now, and I believe we're up to page 11, and I'm going to do something a little different this time. I don't mean to put anybody on the spot. Well, That's exactly what I'm doing. I'm going to put somebody on the spot, and I'm going to ask you whether or not there's a problem with the question. So, is Stacy here with us, or is she on a call? Stacy, you here?
Yes, hi. Yes, I'm here, Joe.
Oh, excellent, excellent. How are you today?
Good. How are you?
You sounded pretty good at the. You sounded pretty confident at the that this morning's briefing. So I hope you don't mind that I selected you. All right.
No problem.
Thank you, thank you. So we're at page 11. And forgive me because I'm reading off of the transcript. I don't have the transcript memorized.
Okay.
So we're at page 11, and the question is at line 3. Just give me the green light when I can go ahead and ask away.
Yeah, go ahead.
Okay, very good. Here's the question. Do you know if that camera captures any images outside of the window?
All right. I would object to form on this.
So your objection is to form. What is the basis of that objection?
I think it's confusing and kind of vague.
I have to agree with you. Your objection will be sustained.
No.
Excellent job. So what's your overall opinion of that question and how it's structured?
I mean, it's not kind of a yes or no question.
What do you mean by that? I mean, because it's... Go ahead. I'm sorry.
Well, no, not really. Not a yes or no question, but it's kind of confusing. What do you know if that camera captures any images outside of the window? What camera? I mean, it's kind of vague. It's not, giving more information.
Right. That's absolutely correct. But you had it right, and then you just gave it away. It's a yes or no question because it's the question is, do you know? Mm-hmm. So the correct answer, the responsive answer would be yes or no. So that's a problem. And if you remember, I said at the beginning when we were reminding our brother counsel whose deposition is going on today, is that he's not going to be asking do you know questions or tagging on the end of it as if you know. Let them say I don't know. So that's a problem question. But you're 100% right. That was very good. And Stacy, you used our Marvel X objections, which was confusing, and you said vague, right?
Yes.
Yeah, so confusing and vague. So your objection is sustained. Okay, can you do a couple more?
Yeah, sure.
Okay, very good. Okay, number 7, line 7 on page 11. Do you know what the storage procedure is regarding any video footage captured? Stace?
Yes. I object to form.
All right, hold it. I'm sorry. So you object to the form. And what is?
Yes.
I need this information, so I want to ask this question. So what is the basis for your objection?
Okay, it assumes facts, not an evidence, and quite frankly, I don't like the question. Plus, I don't like that it's asking. The question starts out with, "Do you know?" And what storage procedure are you? Yeah.
Right. So I don't mean to step on your words, but your objection is sustained, and I will have to rephrase that question so it's in proper form. So that's pretty good. I'm not having such a good time right now, Stace. So let's go to the next question on line 13, and here we go. Ready, Stace?
Yes.
Is there any way you can find out how long it's retained or where it is?
Objection to form.
Nice. And what is the basis of your objection?
I mean, you can answer over my objection, and it's multiple objections. I mean,
all right. Now that was good. Okay. All right. Is going to answer over your objection. That's very good. But you're right. It is multiple. And was there anything in there I mean, I know that clearly there's 2, but was there anything that popped out at you that indicated that it would be more than one question there and built into that? What is it?
Sorry. I mean, you asked if there's any way you can find out how long it's retained, one question,
Right.
and then there's where is it? Second
Right,
question.
right. But if you see the word or, it's probably going to indicate to you, and that's what you're really doing when you're listening to the questions. You know, you're listening for these little key words. You know, like remember last time we spoke about using pronouns, they, them, you know, that'll be some kind of indication that you need to ask something else. And here's a word that draws our attention immediately when you hear or. It's not always going to mean that it's multiple, but in this situation it does, and in a lot of situations, because you're giving a choice there, so it's multiple, and your objection is sustained. Let's go down, so I'm going to skip that one there. Let's go to 19, where the question is, in other words, it's not a private agency or company outside of Citibank. It's Citibank's own employees.
I object to the form.
Are you going to allow your client to answer over the objection?
No, it's confusing and leading.
All right, very good. And that's right. And you have the C and the L under the Marvel Axe objection. So you have confusing and leading. Very good. So let's go to the next page now. That's page 12. And let's go down. Well, you know what? Let's go to number 4. I'm gonna ask this question. Do you know the vendor's name? You have any problems with that one, Stace?
No.
You like the question that starts with "Do you know"? You appreciate those?
I mean, I wouldn't object because I don't like.
I agree.
I'm sorry.
No. Listen to me. Listen, I agree with you. I wouldn't object either. Because the answer is either yes or no, and the answer in here was I do not, and then nothing was followed up on. But we should feel something always when a question starts with "Do you know?" and we have to get out of the habit of phrasing questions with that, you know, that start with "Do you know?" All right, so you should just have a problem with it. I agree with you. I would not object. I don't think anybody would object to that one here. Maybe they would, but how about line 14? All right, here we go. It's conceivable that at some point on March 4, 2009, if Mr. Singh was walking past the window, the camera probably could have captured him, at least walking by. Stace?
Objection to form is speculating. I think the guy's speculating here.
That's really good.
It's leading.
Okay, and I'm glad you pointed out that he is speculating. And it's a good reminder, because when we're giving the instructions at the beginning, we're going to get out of the habit of instructing the witness to not guess. All right, you're going to hear opposing counsel say it all the time. They're going to say, "I don't want you to guess. I don't want you to know." So don't. You know, you don't want to use that, because there are times when you do want them to guess, because a guess could possibly lead you to admissible evidence. So you don't want to rule that out. On the other hand, if you're defending, you know, and counsel at the beginning said, I don't want you to guess at any questions, and if they ask your client to speculate later, you have to object and say, he's just following your instructions. He's not going to guess. You told him not to, you know, so that's good. All right, on to 20. Oh, so your objection is sustained. On line 20, in front of the bank, and when I say the front of the bank, I mean on 2nd Street, are there any signs indicating that there's a walkway and the entranceway is to the right? Is there any signs indicating how to get into the bank from 2nd Street? Okay.
I would object to form. It's confusing.
Yeah, what else? Is there anything else wrong with that?
And multiple.
Yeah, there's like 20 questions going on in there.
Yeah.
So your objection is sustained. But you're right, it is at first, you know, it's confusing. It's definitely confusing. So yeah, that objection is also sustained. So moving on to page 13, and let's go to line 12. As far as snow getting cleaned, right? As far as snow getting cleaned, in your history working as the manager of Citibank, when does the snow usually get cleaned after a snowfall? Stace?
Objection to form. It's vague.
Yeah, it also kind of answers itself, doesn't it? When
Yes,
does the snow
yeah,
usually
yeah.
get cleaned after a snowfall? All right, I'm not making fun of you. This is what, this, whoever this person was, and some people asked me if it was anybody here, and it was definitely not. And if it was, it's okay, because the teaching tool that this has turned into is like, it can't be matched. So this is, the sacrifice was worth it, but it was not anybody here, I promise you. I would never embarrass any attorney, even if they weren't here, by doing this and making them suffer through this. Your objection sustained, counsel. On line 22, when you say it's been cleaned, the entire parking lot and the drive-through?
Objection to form, it's leading.
It
And
is
I
indeed.
also,
Yeah?
and I want to say, what do you mean when you say it's?
Right, but you wouldn't phrase your objection like that, right?
No,
Because
but
that would,
I'm not sure how to.
well, what would you say? Looking at your Marvel Acts objection, would you say it's assumes a fact not in evidence? Would you say it's vague? Would you say it's confusing? Pick one.
So it vague, leading. It's leading. So what do you
Okay,
mean when you say it's? So
okay,
objection
well,
to
that's
form, leading.
your objection is sustained, but it also, with when you're talking about it makes it kind of vague because you don't know exactly what you're talking about. So your objection is sustained. All right. So let's see if I can trick you with this one. This one's a little bit, and I love tricking you, Stay. So number 2, line 2. Does it always include the walkway that's to the right of the bank, facing the bank, the walkway that wraps around the building on the opposite side of the drive-through? Does it also include that?
Objection to form, confusing and multiple.
Nice, nice. All right, but you're getting ahead. All you have to say is objection to form, and you're covered. Okay?
Okay.
Because if you object to form and then state the wrong Marvel Acts objection, you might be in a little bit of trouble there, because you didn't give the opposing attorney the appropriate signal so that they could repair it. Because if you said it was assumes a fact not in evidence, well, I disagree with that objection. So I'm going to continue on. So you say objection to form. Let them ask you for the basis, and then you give the Marvel Acts basis. Okay? Otherwise, you just let it go. Boom, you're protected. That's all you're trying to do. And this is just a comment on line 9 through 12. You have defense counsel, asking to go off not even asking, directing that it go off the record. That's another reminder to our counsel. You're not going to let opposing counsel go off the record without your directive, without your permission. These people, they like to go off the record and they make all kinds of inappropriate comments, or give verbal nudges to their client there, and that's, you want to make sure everything stays on the record. Okay, so I just want to point that out just as a friendly reminder. Okay. All right. Let's go to line 15, Stacy. So the opposite side of the drive-through, wherever that is, not the same side of the drive-through, the other side of the building directly parallel with the drive-through. If it's the west side, then it's the west side if counsel represents. Stacy?
Objection to form.
Then what's the basis?
It's not a question.
It's really like reading a Faulkner novel. It's like this whole stream. It's like the stream of consciousness thing. So of course it's not a question, and it's a statement, and then defense counsel chimes in, and we haven't heard from a witness in quite a few lines here, almost half of a page. Something, because it leaches over to the next page. And that shouldn't be, it's almost a full page, probably a full page of attorneys speaking at a deposition, which is not appropriate, because it's capstoned with the word by the witness, which is correct on line 9 of page 15. So I don't know what is correct here, but you'd have to do a lot of reverse engineering on this answer to find out what's correct. All right. All right. That's enough fooling around. Line 10. In your experience as branch manager, are you responsible for also making sure when you first come to the bank that the grounds are relatively well kept? Stace?
Objection to form.
And what's the basis of your objection, counsel?
It's vague and confusing.
It's V and C, without a doubt. I mean, relatively well kept. I mean, no, I'm not sure what that means. You know, I have an idea of what it means, but remember, we're trying to keep our questions and answers self-contained, and this does not do it. All right, this is a bad situation here. Let's go to the next one, line 16. Your objection sustained. Has there ever been an occasion where the snow removal, in a case where there was a heavy snow, there was a problem, and you called up the main branch, or you made sure it was remediated? Has that ever occurred? Ever? Come on, you said ever. So, Stace?
Objection to form.
What's the basis of your objection, counsel?
It's confusing and multiple.
It's definitely multiple, definitely confusing. Your objection is sustained. So you've been listening, Stacy, huh? I'm glad.
Yeah.
How about? I'm glad. So, although it would have been funny for me if you messed all these up. So, line 23. If you can recall, you know what? I'm just going to start you off right now. If you can recall, is the ugly first cousin of do you know? All right. So here we go. I kind of gave it away a little bit. If you can recall, can you give me an example of when something like that occurs and what happened, Stacy?
Objection to form.
And what is the basis of the objection?
Multiple.
That is correct, and it is sustained. The commentary on the if you can recall, that should just bother you internally and be a reminder to you to not ask a question in that way. All right, why qualify it? Why are you asking that? When you want to say, I don't even know what they're trying to. I guess they're looking for a past similar experience. The phraseology, unfortunately, is lamentable, and they're not going to get, as you can see, they're going to get some kind of crazy answer that's not helpful at all about what they would generally do. Because I know he's asking about what happens after the snowfall and stuff, but if you remember early on in this 15-page depo, that he said that by the time he gets to work, it's usually done. And now all these questions are going on about what happens after, and he's actually testifying to it. So I guess it's not that bad, but I mean, I don't know what they have here that's useful. Okay. Here we go to line 11. This isn't for you, Stacy. I just want to point out, where this is what counsel says. Defense counsel saying, don't assume about records unless you make one. What other people make, you can't. And then the witness says that's correct. Okay, that's at line 11. That is improper nudging. The client now knows the answer. Our questioning attorney was getting close to getting some good information. They were asking about a record. And then, because the defense counsel, who's defending on the deposition, totally derails our attorney. And because of that, they get nothing. About, okay, so maybe they didn't get anything about who might have it, or who would they go to find out if one exists. All right, they missed out on a lot of opportunities to get good information. All right, so now back to the questioning, Stacy. Let's go to line 21. On the date of March 4, 2009, do you recall calling that 1-800 number for any type of facility requests?
Objection to form.
And what's your basis?
It's vague.
It is vague. And again, we have a problem of the question being self-contained. And It's, like what number is this? Did we ever really get a basis for this, what this number is, any foundation for the number? And the answer is no, we do not. We have no information on this thing. And the answer to the question, he does not, what happens is with the question and answer, the only information was that we got from the question is that I do not recall calling that 1-800 number. So, as far as its probative value, there is zero. We have nothing. We have no clues or anything else. Next question at line 25. Generally, do you know the name of the crew that comes in for the facility's snow removal? Stay.
Objection to form.
And what's your basis?
Vague.
I sustain that objection because it's talking about a crew that comes in and a facility and it's not self-contained and he starts off with generally, do you know that, and has the do you know in there. So again, there's a lot of, this is a very, very sickly phrasing for a question. So many problems. Generally, do you know, crew, definition of terms. And here's something that I also want to remind our questioning attorney for today, for today's deposition, is you may have a wily witness and they have been prepped to question any words that are not usual. For example, crew, and the use of the crew. And they may say, what do you mean by crew? First of all, you don't have to be nasty about this, but you don't answer their questions. You remember at the beginning of your instructions, they're to tell you that they don't understand the question. You did not tell them, hey, if you don't understand the word that I use, please ask me and I'll be happy to define it for you. All right, don't let the witness take control, and don't let their attorney do the same thing by asking. The attorney will jump in and say, what do you mean by crew? That's not a question. That's improper nudging. All right, that is not legal. All right, to do that, because what's going to happen is after the witness hears their attorney say, well, what do you mean by crew? They're going to say, I don't know what you mean by crew. What do you mean by crew? Guaranteed, 100%. All right, and the way you deal with it is if you come up across a word or you use a word and they ask you, I don't know what crew means, and the follow-up to keep them on the reservation in the future is to say, well, is this a word that you are unfamiliar with using at any time? Have you ever used the word crew before? If they say no, they never heard of that word before. I think I explained this last time, and we used to carry little dictionaries around just for this purpose. You can go to your phone and go to Webster Online or something and pull up the word crew, and you could actually read it into the record. It's fine. You can, and you could just read the definition and say, do you understand what the word crew means? And and they say, well, there, I understand how it's read there. I say, okay, well, I'm going to ask you the question using the word crew with the meaning that we just provided to you. Is that acceptable to you? I mean, if they want to continue on, it could go on forever. If they want to deny ever hearing the word crew or using the word crew, or they're just unfamiliar with it, then that's fine. Move along. And if you can't find another word other than crew, take a break. Go in and go look for a synonym. And again, on Webster Online, they give you the synonym for any of the words that you want to use. It's okay to do that. All right, and that's how you deal with these people, that have been prepped to say, I don't know the meaning of that. Line number 5. Your objection was sustained, by the way, Stacy. Line 5 on page 17. And by the way, when you're arguing a motion or if you're using the deposition transcript at trial, and I know you attorneys know this already, but when you're referring to, you say, I'm referring to the deposition of, whatever this is, December 1st, 2015, and I refer the court to page 17, line 5. That's the way you do it. So line 5's question, Stace, here it comes. Generally, when the snow removal is done, have you observed them dropping salt or rock salt all over the property? Dave?
Objection to form.
And what's the basis of your objection?
It's confusing.
It is confusing, because we're asking, first of all, the question asks, generally, and then it goes in the same question asks for specific, whether anything was specifically seen. So the syntax of the question is definitely problematic. You can object to the form, and you could allow the witness to answer over the objection, but at least it is preserved. And the answer is definitely. And nothing was taken from that other than definitely. So your objection is sustained, Stacy. So line 10. And that includes the path and the walkways.
Objection to form.
And what's the basis there?
It's leading.
It is definitely leading. It's calling for a yes or no answer, which does not always mean that it's a leading question. Like, you can reverse engineer the answer yes or no and get to an open-ended question. So it's not always, but it usually is an indicator that if the answer is yes or no, that the question's probably going to be leading. So your objection is correct, and the objection, the leading objection, is sustained. But if you were asking, Stacy, if you were at a deposition and you were defending somebody and they were asked a question like that, and would you have objected, or would you just let it go?
No, I would object.
You would object. Okay. All right, because there was no objection here. So it's just a matter of style and whether or not you wanted to make it any worse than it was. But I think it was fine.
Okay.
I agree with your objection. And I think we are at our final question. So far, you're batting 1,000. So
it's kind of hot in here, Joe.
Okay. Okay. So line 16. Would it include, of course, the drive-through area?
Objection to form.
And the basis?
It's leading.
Yeah, it is leading, and it's. I mean, I don't know what they were. I think that they needed the answer to that question, but that they could have got way earlier on in a much cleaner transcript. So your objection is sustained on that, and you did a really good job, Stacy. So I appreciate you that you. I know now you definitely paid attention. So thank you. So that's great. All right. So there you have it, Stacy. You're off now. So there you have the entire deposition. You heard the objections to that deposition and how it works and what kind of problems you can run into, so that if you're asking questions that do not begin with who, what, when, where, why, who else, and what records, then you're going to understand why your questions are being objected to. And if Stacy gives you an objection, and you ask for the basis, then you'll be able to turn that problematic question into an open-ended one that starts with who, what, when, where, why. And I promise you, if the attorneys, the questioning attorney in this deposition had used the open-ended questions, they would have had much more useful information, and the portals would have opened to so much more information, so many more questions to ask. But because of the poor phraseology of the question, the deposition transcript is only 15 pages. Now, it's not only because of the problematic syntax, it's also because they did not have a plan. And today's attorney does have a plan. And we went over this and a couple of times now in the Redder versus Recovery Physical Therapy. And we have our quadrant set up with the pedigrees and the history of the PC, the event details, and the aftermath. And it's okay. And if I ever suggested that you should have your questions numbered and you should read off read off your written out questions, please. That nothing could be further from the truth on that. But I do recommend that you have your outline there with your quadrants there, just to make reference to it if you don't want to look at it. You know, I always do. I always have it, and I've done so many depositions. But you know what? It's always good to have that there, because at the end of the deposition, and this is for our questioning attorney today, at the end, when they think that they're finished, before they close the deposition, they should take a break, go off the record, take their quadrant, go through their notes, and make sure that they hit everything and that they feel satisfied. There's no rush. You take as much time as you need. It's your deposition. You can do it, and just go over your quadrant. This way, you have your quadrant notes right there, and this way, there's no guessing. So, I do have a handout for today that Katrin has prepared. It's not anything fancy like Katrin does. Maybe she'll turn it into something later on for the final presentation. But anyway, it's an outline for corporate form. And Greg suggested that we talk about this because the question comes up about, you know, about how do you pierce the corporate veil, meaning that, you know, for the non-attorneys, you know, you have this limited liability company, you have this corporation set up so that you protect yourself individually. But how do you get at the individuals? And, you know, to get, and usually, unless it's a wage and hour case or it's a discrimination case where they actually did something, the named party, you're not going to pierce that corporate veil. And this is a situation that exists now in the Redder physical therapy case, which is a PC. And we have, in this case, we have the therapist individually named. So at some point, unless this is explored, their attorneys are going to make a motion to dismiss the case against the individual because we have the PC that is named, and they are protected by the corporate entity that they have created to limit their liability. That's why you create these limited liability entities. So we have to find out whether they followed the corporate form. Because if they didn't follow, and I'm going to explain this a little bit more in a minute, if they didn't follow the corporate form, then you can go at them individually. So the part of the questioning that our attorney is going to be engaging in today is about whether or not the corporate form was followed, and this is an outline just for that specific area, because it's not a common area that we get into. Well, our firm actually does it quite a bit, but this is a situation that does not come up all the time. So I think it's important that in addition to your quadrants sheet that you have set up and your Marvel Acts objections there to remind you what objections that you have in case you have to state a basis for your objection, that you have this also. And you'll see we start out, well, it's actually made up, if you look at it, it's made up of 4 sections. The first section is separate personal and business assets. And you're going to ask questions about this. And there may be objections to it, which is fine. You know, you're going to let them object all they want, but they have to answer the questions. And if they don't, then you'll have it marked for a ruling. And before you have it marked for a ruling, you will get the witness to decline to answer, to refuse to answer, and then you will get their attorney directing their client not to answer, so your record is made. Because it is very relevant to this case. Because if they have not followed the corporate form, you're going to go at them individually. So, section 1, personal assets and business assets kept separate. You're going to ask about that specifically and how they are kept personal and separate, and what records they have. Different bank accounts for personal finances and those of the company. You're entitled to ask about that, whether they use any money that belongs to the company for your own personal reasons that are not business related. And that which goes on to the corporate funds on personal needs. And then talking about and asking about money transferred is needed for distribution to a personal account prior to purchasing personal items. Wanted to buy that new Mercedes, and you didn't have any, the full amount in your own personal account, so you took some from your company. It's your company, right? You can do what you want with the money, right? Wrong. That's a violation. And if you can prove that, then that shows that they did not follow the corporate form, and you can go after them individually. The second part is maintain adequate capital. You can ask about the capital health of the corporation, because it's relevant. They're required, and you see they're required to have sufficient capital for incorporation and to operate the business while maintaining the integrity of the corporate veil. And you're going to find out and ask questions about loans and investors and the origin of these things. Going on to the third part, which is the essential guidelines and formalities observed. Did they perform all the annual filings that are required? Find out what what they are, what these filings are, whether they issued membership certificates to owners, developed and updated the operational agreement, developed bylaws and updated them regularly, paid taxes and all necessary filings. And this is a good one, because this is when they always screw up, is the scheduled annual meetings of shareholders. Even if it's a single shareholder, they're required to keep records that something was done in their books. And you see the corporate kits when they come out during litigation, which is something that you're going to be asking for. There's nothing filled out. There's no records kept of any kind of meetings or anything like that. So, or any kind of distributions or certificate issuance. So that's something that you have to ask for too. So that's number 3. And then finally, for the minutes of these shareholder meetings, and for those in transaction, very well what these are. Those are the notes that are taken from the meetings, what was discussed, who was there, when it took place, and all that good stuff. And that usually those are signed and they're kept as part of the corporate book. Excuse me 1 second. Let me just get this bag over here. I'll be right back. So we're going to be asking about the shareholder meetings, the setup of the formation. You're going to talk about the ledgers of all the shares, if there's any issued to shareholders and their value, the records of payments made and received, invoices, statements. It sounds like it's really nitpicking, but this is how you can do a whole deposition on just trying to set up the piercing of the corporate veil. And this is your guide. This is your quadrant within the quadrant. Okay, that's why I broke it up into 4. It's your quadrant within the quadrant, and usually that will come in the second master quadrant. And this will give you plenty of materials to find out what it is that you're looking for. And you know what? You might not find anything, and that's okay, because at least and you did your best to maximize the wealth of your client by making sure you didn't have another deep pocket to go into. And that concludes our session for today. And we covered quite a bit. I know Stacy must be exhausted, but she did very well. Congratulations, and thank you for at least paying attention. You're not a lawyer yet, but something tells me that may change. No pressure. And now I'll take questions. And before before the first question comes, I do want to, for non-attorney personnel to think about what they could do to get people ready. Like, what could they have done for our assigned counsel for today going out on this deposition? And the answer is very easy. It's something that they can manage, and it's in the CPLR. There's 2 things. There's CPLR 3111, and then the CPLR 3102. CPLR 3111 allows you to create what's called a notice to produce. And the notice to produce directs the opposing side to have their witness produce certain specific documents. So that you could have taken your quadrant within the quadrant on the corporate veil and specifically told them to produce these documents or copies of them at the deposition itself. 3111 of the CPLR, notice to produce. It's awesome. Check it out. The second thing that we could have done for our questioning attorney, so I'm just assuming it wasn't done, but this is what staff should be considering. 3102 is a specific notice that demands that you be given access to the specific area where the accident took place. So you can go in there and video it, take pictures, draw a diagram of it, and and do things like that. So imagine having all that stuff going into the deposition. Imagine the questioning, you're the questioning attorney, and you have been to the office where Mrs. Redder fell down and hurt herself, and you're able to, you're, instead of creating a construct out of emptiness, you in your head, you know what it already looks like. So you can start putting the things there that you already know exist, instead of guessing as to what it is, or depending on the memory or the ability of the witness to articulate what the premises looks like. So there you have the CPLR 3111 and you have CPLR 3102, and it specifically says that you can notice the other side to give you permission to go onto the premises and take pictures and walk around and do whatever it is that you want. And that's it. Okay, so it's we have like 8 minutes or so left. And are there any questions, comments, any things that people think need to be added for our counsel who's conducting his deposition today?
Joe, I have a question.
Yeah.
What does it look like to the attorneys if your witness doesn't remember anything?
It looks very bad, especially after you develop that you have a record where they don't remember anything at all. And as soon as you detect that you have one of these witnesses who just don't remember anything, you have to ask other questions about the time period that you have targeted. So say it's like, you're not going to ask questions about the case, but you're going to ask about what season it was, what you were doing there. Get them as close as possible to the event that you're questioning them about, and build up what they have memories of. And you'll be surprised. They'll give you all these details that are just saying showing that they have this incredible mind. And then you go back again, which you're allowed to do, even over the objection of opposing counsel, who's going to say repetitive, asked and answered, and but then then they're going to say that they don't remember again. But meanwhile, they gave you all this detail about other things that were so close in time, yet you can't remember an important thing like running over some guy's bike, or something like that. That's how you deal with it. But the answer to the question is, how does it look? It looks terrible. It looks terrible. I mean, when they were asking, and I hate to besmirch his name because, Joe Paterno from Penn State, when they were asking about the kids who were molested there, and he said they asked him about whether he had knowledge about about anything at that time, and his first response was, "I don't remember what I had for breakfast this morning. How am I going to remember back then?" And then they asked him questions about the games and the practices and gave details about but was unable to remember, and I'm sorry for putting Joe Paterno in a bad light like this, but it's the first instant that came to my mind when you said that. So it looks bad.
So it looks bad that you don't want to use them as a witness for trial, or?
It depends on what it is, and your transcript that you're reading back, you're going to get a sense of how it reads. If they don't remember, if they really don't remember, and they just can't, they just can't remember. Sometimes it's for medical reasons. Like in accident cases, we see it all the time. Trauma has this like concentric circle, ever increasing concentric circle effect of erasing memory, going forward, going backward, sideways, upwards, downwards, because that's how the mind protects itself. So you have there's this blank of information, And the mind, the way it works is it tries to recreate the events with what information that it has. It extrapolates, and it's called, confabulation. It's not actually a true memory from that trauma. It's what their mind believes it is, because the mind doesn't want those blanks in there. It has to be filled with something, but the trauma is too intense for it to have that exact memory in there, because it won't let the mind continue to function normally with that bad memory. So there are times when the memory is just not there. So it's not an easy question, but if they really don't remember, they don't remember. But in most cases, if there's no medical explanation for it, they know, and it's just a matter of finding out. It's like, look, people are busy. People do a lot of things depending on what their jobs are, and they have a lot of events and multiple traumas, like, firemen, firefighters, they deal with multiple trauma, all day long. They've been to, 3 fires in a day, and you're asking them about fire number 2 and what they did exactly, what floor they were on. They're not going to remember, and they're telling the truth. You'll know when it's somebody who's just avoiding answering the question. You'll know. You'll get a deep sense. Not that we can detect lies, but based on their memory of other things around that situation so close, you'll be able to tell whether they're lying. It's a good question.
Just a comment on your inspection of premises and the potential value it can have. You just reminded me of your mention of firefighting. We had a woman fall off a 5th-story roof onto a 2-story store rooftop. The balustrades around the roof were a point of contention at their being too low. And when you present that to a jury, you say, well, this balustrade was only 24 inches. It's too low. Yeah, that is what it is. We went to the roof and looked. The purpose of those balustrade heights are, if you have a balustrade that is knee high back at the turn of the century, it was a signal to firemen when they're on the roof and a building's on fire and there's no lights and there's all the smoke. If the balustrade comes up to your knee, you can jump over it and land on the roof of another building. If it comes up to your hip, if you jump over it, you land on nothing. Going up to the roof to show that very low balustrade that jumped off into nothing really put it into a perspective that a jury could suddenly understand that balustrade is wrong and it should have been fixed years ago. The second point of it was when we looked over the balustrade, we saw the portable respiration device that was used on this particular plaintiff that was left on the roof of the other building by the firemen, which really hit home.
That is incredible, and just like an unbelievable example of how that could be useful to you, for the lawyer, for the questioning, the examining lawyer, to actually experience that and understand, what emotions they're trying to evoke. It's just, that's a great example, Greg. So I hope you guys remember that. All right, guys. So that's it for our hour for number 5. Good luck to our assigned counsel today on his deposition. I hope that these 5 installments have been helpful to you. And I hope that at some point during one of the installments that you'll be able to share your experiences and see how we all can learn from your experience. So I'll see you all next time. Okay. Thanks a lot, everybody.